Welcome to Lecture 11, Who's Watching the Watchers? Internet Regulation and Privacy. The efficient and effective regulation of the Internet and the concomitant concerns over the privacy of personal information poses a formidable challenge. Personal information has become an increasingly valuable commodity. The rise of the Internet, coupled with technological advances, have enabled the collection, aggregation, and use of personal data on a scale never before imagined. There are varying approaches on how best to protect our privacy in our age of information abundance. This video lecture briefly highlights the different privacy protection approaches taken by the United States and by Europe, and provides a summary of the various means by which personal privacy interests are protected and enforced in the U.S. In Europe, government plays a central role in the recognition and enforcement of personal privacy rights. The European approach is a proactive umbrella approach, focusing on privacy as a fundamental right of a citizen. Broad standards and principles apply to all consumers and to all businesses across all industries. The emphasis is on individuals, and government is the primary enforcer of the standards and principles. The EU's approach to privacy grows out of the 1995 EU Directive on Data Protection, which mandated that each EU member nation pass a national privacy law and create a data protection authority. Updated legislation was proposed in January 2012 to address changes in technology and to specifically recognize a right to be forgotten. The backbone of the European approach is the principle that privacy is a fundamental human right and that government is best suited to protect that right. In many parts of Europe, personal information cannot be collected without a consumer's permission, and consumers have a right to review the data and correct any inaccuracies. In most European countries, companies that process data must register with the government and are subject to considerable regulation. Employers cannot read workers' private email, and personal information cannot be shared by companies or across borders without express permission. By contrast, the U.S. approach is primarily a market-based approach that emphasizes self-regulation with voluntary codes of conduct and best practices formulated on an industry-specific basis. Protection and enforcement of privacy rights in the U.S. is through a combination of contractual agreements between a company and a consumer, specific and limited authority of government to enforce those contractual rights, and private litigation. Whereas Europeans have an inherent distrust of corporations, Americans are more concerned about government invading their privacy. U.S. privacy laws and approaches have developed over time and often in a haphazard way in response to a specific privacy incident. For example, passage of the Video Privacy Protection Act was in response to the publication of Supreme Court nominee Judge Robert Bork's video rental records by a newspaper during his confirmation hearings. The patchwork quilt nature of U.S. privacy laws have also resulted in part because privacy concerns have been addressed at both the state and federal levels, often in inconsistent ways. There are 5 primary players who have a role in addressing personal privacy issues in the U.S. These include the federal government, state governments, NGOs, private litigants, and industry. Let's briefly review each of these privacy stakeholders. Over the years, Congress has enacted dozens of laws specifically addressing privacy issues. Some of the more important laws include the Privacy Act of 1974, the Computer Fraud and Abuse Act of 1984, the Electronic Communications Privacy Act of 1986, the Driver's Privacy Protection Act of 1994, the Children's Online Privacy Protection Act of 1988, the Video Privacy Protection Act of 1988, the Telephone Consumer Protections Act of 1991, and the Health Insurance Portability and Accounting Act of 1996. Various federal agencies have rulemaking authority to address privacy issues. The principal consumer privacy watchdog is the Federal Trade Commission, which may file enforcement actions when consumer protection laws are violated or when information providers or websites violate the terms of their privacy policies. Over the past 3 years, the FTC has brought numerous enforcement actions and has levied millions of dollars of fines against companies who have violated the terms of their privacy policies or violated federal privacy laws. Currently, Google and Facebook, pursuant to the terms of a settlement with the FTC, must obtain users' express consent before materially changing the terms of their data practices and are subject to an annual outside privacy audit for 20 years. In March of 2012, the FTC issued a recommended privacy framework for companies to voluntarily follow in protecting consumer privacy. The privacy framework, which includes best practices, is predicated upon 3 principles. Privacy by design, which means building in privacy in every stage of product development. Simplified consumer choice, meaning giving consumers the ability to make decisions about their data at a relevant time and in a context. And finally, transparency, meaning making a company's data collection and use practices transparent. President Obama, in February of 2012, issued a Consumer Privacy Bill of Rights, which focuses on transparency, context, security, access and accuracy, and accountability. Several states, most notably California, have been active in privacy regulation in such areas as data breach notification, GPS tracking, prohibiting employer access to employee social network passwords, access to cell phones and email records, and use of drones for surveillance. The leading non-governmental organizations that focus on privacy policy and enforcement include the Electronic Frontier Foundation, which is active in privacy litigation throughout the country and has recently been focused on protecting privacy of automobile data. The Center for Digital Democracy, which focuses on privacy research and public education. The Electronic Privacy Information Center, which has been particularly active in privacy issues surrounding electronic health records. The Center for Democracy and Technology, which lobbies state and federal legislative branches on a host of privacy issues, and the American Civil Liberties Union, which primarily uses the courts to enforce privacy rights, including numerous Fourth Amendment challenges to government actions. Private litigants also provide varying degrees of privacy protection and enforcement. Many privacy statutes create private rights of action, and class action lawyers have been particularly active in privacy litigation of late. For example, Facebook just recently settled a class action involving its Sponsored Stories ad program by paying $20 million and revising its terms of use. And finally, there are active efforts at industry self-regulation. Numerous industry trade associations have formulated a variety of voluntary best practices and guidelines in an effort to stave off government regulation. Some of the more visible efforts include the Digital Marketing Alliance's Privacy Promise. The DMA is the country's largest trade association for businesses interested in interactive and database marketing. The DMA has required members to agree to allow customers to opt out of the sale or sharing of their names and to honor a request not to receive further email or telephone solicitations. The DMA has expelled members who failed to comply with their privacy promise. Several so-called privacy seal programs have also been developed to essentially give a good housekeeping seal of approval to websites, ads, and mobile apps. The most recognizable privacy seal program is by TrustE, a for-profit data privacy management company. Trustee allows companies to display their seal if the company has complied with certain privacy and security principles and practices. Over 5,000 businesses are currently allowed to display the seal. The Digital Advertising Alliance, a consortium of the 6 leading advertising and marketing trade associations, was formed for the specific purpose of establishing and administering self-regulation principles for online data collection. The DAA recently released a set of online behavioral advertising principles which it requires member advertisers to follow. The linchpin of the DAA program is an icon, which is prominently displayed on each ad covered by the principles. Clicking on the icon brings up a brief statement about online behavioral advertising with an additional link for the consumer to opt out of advertising from all DAA member companies or from specific ones. The icon is being served in over 1 trillion ad impressions per month. Hundreds of companies are participating in the icon program, and more than 1 million consumers have opted out of receiving targeted advertising since 2001. The program is enforced by the Council of Better Business Bureaus. The industry has trumpeted its self-regulation efforts to the public and to Congress and warned that government regulation will seriously harm a multi-billion-dollar industry. Critics have said not enough companies are participating, there is no real penalty for noncompliance, and that the general public is unable to easily understand how to protect themselves through these self-regulatory programs. The debate over whether online privacy is best protected by industry self-regulation or by government regulation will continue to be a hot one in the next few years, not only in the U.S., but around the world. Will the European regulatory model carry the day, or will the American free market model prevail? Only time will tell. In the next 2 video lectures, we delve deeper into data mining, data brokers, targeted advertising, and do not track proposals.